Grab your chai, guys, because today we're untangling something literally every Pakistani lawyer and honestly every citizen needs to know. Welcome to The Explainer.
Exactly, Bisma. आज हम पाकिस्तान के फैमिली लॉ की पूरी आर्किटेक्चर को ब्रेक डाउन कर रहे हैं. No dense textbook jargon today.
Just the complete legal framework, totally simplified.
Because family law isn't just about commercial disputes. ये इंसानी जिंदगी के सबसे अहम हिस्सों को टच करता है. Marriage, divorce, custody.
And for most citizens, the family court is literally the only court they're ever going to face. So, Amr, shuru kare? Okay, first question. Why is there no single unified family law code in Pakistan? ऐसा क्यों लगता है कि laws हर जगह बिखरे में?
It really is scattered. It's this massive historical mix of Islamic jurisprudence, colonial legislation, and modern amendments.
Which makes it incredibly tricky to navigate, right?
Oh, for sure. But here's the real kicker. Picking the wrong court literally equals a nullity.
Wait, यानी पूरा केस साया?
Yes, you could have a flawless case, perfectly argued, but if you file it in the wrong court, your entire decree is void. Zero.
Wow. Okay, let's map this landscape out so we don't make that mistake. हम 6 main statutes deal कर रहे हैं, right?
Right. First up is the Family Codes Act 1964. ये आपका core procedure है.
Then we've got the Muslim Family Laws Ordinance, the MFLO 1961. That's for registration and talaq.
Spot on. Next is the DMMA 1939. That governs how a wife can actually get a judicial dissolution.
और बच्चों के लिए?
The Guardian and Wards Act 1890. That handles all the custody and guardianship stuff.
Plus the Dowry Act 1976 for bridal gifts.
And finally, the modern provincial domestic violence acts. ये सब मिलके एक complex machine की तरह काम करते हैं.
Let's focus on that first one, the Family Courts Act.
अगर मैं family court में हूँ, can I just use standard civil procedure tactics?
Absolutely not. And that's a massive error even seasoned lawyers make. The family court has exclusive jurisdiction under Section 5.
But what about the civil procedure code, the CPC?
Section 17 completely excludes the CPC.
Completely ignored. Kyun?
Because the family court is designed to be a specialized, fast-paced inquisitorial forum. It is deliberately freed from the slow, endless machinery of civil procedure. But Amir, what if both the husband and wife mutually agree to go to a civil court? Like, just for convenience.
Doesn't matter at all. The law is merciless here. Let's look at the Muhammad Nawaz case from 1985.
अच्छा लाहौर हाई कोर्ट ने क्या कहा था उसमें?
They explicitly ruled that a civil court's decree in a family matter is a complete nullity.
Even if both parties actively consented to being there?
हाँ, बिल्कुल. Consent cannot confer jurisdiction. If you bypass the family court's exclusive power, आपकी hard-won decree completely worthless है. No exceptions.
That is a huge trap to avoid. Okay, moving to the second statute. The MFLO 1961. इसने classical law को drastically reform किया था, है ना?
Yes, it introduced some massive procedural changes. इसकी 5 key provisions हैं जो हर practitioner को याद होनी चाहिए.
Let's break them down.
Section 5 makes marriage registration absolutely mandatory. Section 6 requires arbitration counsel permission for a second marriage.
And Section 7? What does सबसे famous है?
Right, the mandatory 90-day written notice for talaq.
Then Section 9 handles maintenance applications to the Union Council.
And finally, Section 4 protects orphaned grandchildren's succession rights, basically modifying those older classical exclusion rules.
Let's zoom in on that Section 7 timeline, because it seriously causes so much confusion. ये 90-day clock आखिर काम कैसे करती है?
Well, classical talaq was heavily modified here. You can't just pronounce it verbally and walk away anymore.
So if a husband verbally pronounces talaq on day 1,
It literally means nothing legally unless he sends a written notice to the Union Council chairman.
oh, so the 90-day clock only starts ticking upon that written notice?
Exactly. The clock starts on the written notice. एक दिन पहले भी नहीं.
But what if a husband verbally pronounces it, just waits 90 days, and then claims, hey, time's up, we're divorced?
The Supreme Court completely shut that exact argument down in the Nasrin Akhtar case back in 2008.
So there's no way he can circumvent the notice requirement?
Bilkul nahi. The verbal timeline is totally irrelevant to the law. A talaq that isn't formally notified in writing doesn't just become effective because 90 days guzar gaye.
All right, that secures the procedure for the husband. But what about the wife's right to actually exit a marriage?
Amir, historically, before 1939, it was incredibly difficult. Then the DMMA 1939 came in, laying out specific grounds like cruelty or neglect. Lekin agar physical abuse na ho to, what if she simply finds the marriage intolerable and just wants out?
That brings us to the brilliantly expansive 9th ground of the DMMA.
Which says what exactly? It allows dissolution on any other ground recognized as valid under Muslim law. Or legally, iska matlab hai khula.
But Amir, Historically speaking, didn't khula always require the husband's consent? शौहर की इजाज़त ज़रूरी होती थी ना?
It did, right up until the single most revolutionary judgment in Pakistani family law history.
You're talking about Khurshid Bibi versus Muhammad Amin, 1967.
Yes, the Supreme Court established that a wife's right to khula falls squarely under that ninth ground.
So the absolutely crucial point here is no husband consent is needed anymore?
Zero consent required. It fundamentally shifted the entire power dynamic. As long as she's willing to return the dower, the court can and will dissolve the marriage, chahe shohar inkar hi kyun na kare.
Let's make this practical for a second. Ayesha goes to court for khula. Does she have to prove to the judge exactly why she hates him?
No way. And that principle was cemented in Humaira Mahmood versus the state, 1999.
The court uske reasons ki validity check nahi karegi?
The court is actively not required to investigate the reasonableness of her aversion. It's not some discretionary remedy.
What does she actually have to do then?
Just swear an oath. Her statement on oath that she cannot live with him within the limits prescribed by God is legally sufficient. Bas uska bayan hi kafi hai.
Okay, dissolution is clear. Ab bachcho ki baat karte hain. Custody battles are always the absolute messiest part.
They are, and the core legal friction here is between technical Islamic Hizanat and the Guardian and Wards Act 1890.
Hizanat being those strict age-based custody rules, like a mother gets the son until age 7?
Exactly. But Section 17 of the GGWA introduces a much broader overarching principle, the overall welfare of the minor.
And what happens when those two concepts inevitably clash in court?
Welfare overrides Hizanat, Hamesha.
Is there solid Supreme Court backing for the welfare principle overriding those strict Islamic rules?
Absolutely. Just look at Miss Rubina Bibi in 1988 and Iqbal Hussain Shah in 2018.
Supreme Court ne un cases mein kya establish kiya?
That Hizanat rules are merely presumptions. They're not absolute mechanical rights.
So a court won't just blindly hand a 7-year-old boy straight to the father?
No. Agar maa ne dusri shaadi kar li hai, or if the child's welfare clearly demands something else, the court will depart from those technical rules to protect the child. Bacche ka fayda sabse upar hai.
So we have all these statutes and principles constantly overlapping. Courts in conflicts who actually resolve kaise karti hain?
It's all about understanding statutory precedents. It's like a giant puzzle, but once you see the pattern, it's totally clear.
Like the MFLO written notice beating classical verbal talaq?
Yes, statutory procedure prevails.
And DMMA khula beating classical husband consent requirements?
Exactly. The statute overrides the classical restriction every time.
Same for GWA welfare beating strict Hizanat ages?
You got it. And even the newer provincial DVA acts, they don't conflict. They actually run in parallel with family courts to offer really fast supplementary protection.
But going back to procedure for just a second, what if the Family Courts Act is genuinely silent on a really specific issue? Kya lawyers CPC ko wapas la sakte hain?
Nice try, but no. The Supreme Court permanently blocked that loophole in Fahmida Bibi versus Sukhan Muhammad.
So it's literally a complete blockade?
A complete and deliberate exclusion. You cannot wholesale import civil delay tactics.
Thoda sa bhi nahi.
The CPC can only be applied by mere analogy if the act is completely silent, but you can never ever use it to drag out family proceedings.
Okay, this has been an incredible breakdown. Let's summarize this entire framework by busting a couple of common myths people still believe.
I'm ready. Let's knock them down.
Myth 1. I can use standard CPC civil procedure to fight my case in family court.
Ghalat fahmi. Absolutely busted. Section 17 excludes the CPC entirely. The family court is an inquisitorial fast-track forum.
Myth 2. A wife is totally trapped because she needs her husband's permission to get a khula.
Completely busted. Under the DMMA 9th ground, the court can and will decree khula without his consent, purely based on her simple oath.
So we've basically mapped it all out. Procedure, registration, dissolution, custody, dowry, and domestic violence.
It's a remarkably powerful, interconnected architecture once you actually see how all the pieces fit together.
Amr, before we wrap this explainer, what is your one final practical tip for someone about to start a family law matter?
Read the Nikah-nama. Literally read it column by column. वो कागज का टुकड़ा आपके client के rights का absolute primary source है. Before you cite a single statute we discussed today, you need to know exactly what was signed on day one.
Start with the contract. Brilliant advice. Thanks for joining us for this explainer, Amr. And to everyone watching, apna khayal rakhein. We'll see you next time.